I've had so many physicians talk to me who have either built their real estate portfolios without the right legal structures to protect them. I've talked to so many physicians who get stuck with the first step where they're trying to create an LLC and then that's preventing them from taking action because they're so overwhelmed with all the options out there. And then I've also seen those who create elaborate structures for asset protection and end up not using them. And so today I'm super excited to be joined by Jeff Hampton, who is co-founder of STR Law Guys. He is also a best-selling author. He is himself a seasoned real estate investor. I know he owns short-term rentals, and he's a national asset protection lawyer who's helped hundreds of investors protect their assets and create generational wealth. And we are excited to be deep diving into what real estate investors need to know about asset protection as they start their portfolios, how they should pivot as they scale. Again, I think for the first time, we're going to be talking about the unique aspects of asset protection for short-term rental owners. And I know within our coaching program, the majority of our students own short-term rentals. And so very excited to get started.
Welcome to Generational Wealth MD's podcast on financial freedom through investing in real estate. My name is Param. I'm a mom, radiologist, real estate investor, and mentor to others looking to start or scale their real estate portfolios. The goal of this podcast is to provide you with inspiration, strategies, and insight so that you can stop trading your time for money and live life on your terms. If you love the episode, don't forget to subscribe and leave a review.
Thank you so much, Jeff, for hopping on and doing this with us.
No, thank you, Param. I'm excited to be here. And of course, I love talking about asset protection, and I'm excited to share and do all I can to provide value tonight. So thank you for bringing me on.
So I just ended up listening to one of your previous, educational sessions, and you are an educator at heart. You break things down very simply. So, but as we start, I want to talk about your journey. And I was surprised to learn that you used to originally sue short-term rental owners and commercial property owners for premises liability lawsuits, and then you've since then transitioned. You became a short-term rental owner yourself, and now you're helping short-term rental owners with asset protection. So tell us a little bit about the journey and how what made you pivot and how things have been for you.
Yeah, so that's right. So when I first came out of law school, I actually worked as a prosecutor, as a trial lawyer for a number of years. And then I got out, and I do have a criminal defense practice that I'm not really a part of anymore, but my primary practice that I was in for a number of years was a personal injury law firm. And for whatever reason, we had a pretty good number of premises liability cases that we would take on. And we really started finding out, shockingly, and I was a little surprised at how uninsured, or many times they just were either underinsured or they didn't have the right policy for many short-term rental owners when someone would get hurt. So let's say somebody came and visited a property, and sometimes there were tragic events like, drowning in a pool, or just a lack of maintenance for something that caused someone to have a very serious injury. That would lead us into lawsuits. So I brought a number of premises liability lawsuits over the years, and I still have some interest, a controlling interest in part of that law firm, but I started investing in short-term rentals. So for me, as I was doing this, I began to look at it and said, okay, wait a minute. Okay, I remember what works and what didn't work when I'm bringing some of these lawsuits against people related to premises liability. That led me to kind of, as I began to buy my own short-term rentals, I started sharing with a lot of short-term rental investors just ways that I knew that they could try to, protect their assets. And that was kind of the beginnings of me partnering with my partner, Stephen Tobin, who's been doing asset protection for 16, 17 years or more. And him and I partnered together to start STR Law Guys, which, quite frankly, there is a gap in the market. There's a lot of discussions about asset protection and things like that, but short-term rentals are very unique in terms of their risk profile, because you have so many thousands of people potentially coming in and out of that property. And you're actually at a much higher risk than, say, if you're just doing a long-term rental or even a mid-term rental. And so I wanted to make sure there was so many kind of, I don't want to say mom and pop, but just retail investors that are out there trying to get started in short-term rentals. And they're great. I mean, we make multiple six figures on our short-term rentals for my wife and I, but many times people get so excited about the tax benefits and all the cash flow that they don't stop to think, hey, I need to be thinking about how to make sure and protect myself, because it's not just what I make, I want to protect myself from losing it. And that kind of what led us to starting STR Law Guys. And now we've been able to help literally hundreds and hundreds of investors throughout the entire country help protect their assets. I think the only two states we have not done work in is Kansas and Alaska. But outside of that, I guess there's not that many short-term rentals in Kansas or Alaska.
Yeah, I thought you were going to say California because it has some very unique aspects to investing in California, but we'll get to that later. No, and you're absolutely right, Jeff. Even in the physician community, there's so many physicians, and for the same reasons that you mentioned, right, who are interested in investing in short-term rentals because you can, with a single property, get sometimes six figures in cash flow, and you can get six figures in tax savings depending on, whether you're able to materially participate. So there's a lot of interest. We have a lot of physicians who do invest in short-term rentals. And for anyone listening and you're thinking, okay, how does a physician who's working full-time or two-physician family do this? We have our 3-day event coming up in March. If you haven't signed up yet, that's generationalwealthmd.com/event. It's very high yield. We talk to you about investing in real estate from all the way from syndications to short-term rentals. And we have other physicians sharing their stories. So make sure you sign up. There's so much that you can learn. It's completely free. It's virtual. So there's no reason why you shouldn't be doing that. But coming back to what you just said, Jeff, and I feel like, always starting off by talking about the mistakes and the challenges is powerful. And then I know you talk about layered asset protection. I'm super excited to deep dive into that. But, with your experience and after having sued hundreds of property owners and having defended many now, what have you seen as some of the common mistakes that you've seen investors make as they're attempting to protect their short-term rentals and real estate portfolios in general?
Yeah, well, one of the mistakes that I see, and there's lots of them, but the first one is not really considering your financing before you decide the type of protection that you need. And one classic example of this is when people reach out to me, one of the first questions I ask them is I'll say, okay, you're about to buy a property. If you're going to buy a property, are you using commercial financing or are you using conventional financing? Because if you're using a commercial loan, a debt service coverage ratio loan or something like that, close in an LLC. If you're using a conventional loan, then you can't close in an LLC. But most people don't realize once you close in your personal name and then you turn around and you want to move it into an LLC, 75 to 80% of states have what's called a real estate transfer tax. And it can really grab you, and you can end up having to pay a very hefty tax. Some states like Michigan with a 3% tax, you've got, Florida at a 1+%. And if you're buying a let's say you're buying $1 million, $1.5 million house, that can add up. And so one of the mistakes is to make sure you need to look into this before you finalize not only your loan options, but before you get to closing, because there are ways around this. And I know we're going to talk about that here in a little bit, but that's number one. Number two is people have the idea that all LLCs are created equal. They just think that if I set up an LLC and I dump a property into it, it protects me. But in reality, that's very rare. Actually, there's only a handful of states that actually provide you the two big things you want, which is privacy. You want to have some privacy so that, greedy lawyers aren't able to do asset searches like I used to do, looking to see who's actually in control and running that property. And then the biggest thing though is charging order protection, which is only a handful of states make it to where when I say charging order protection, if I normally were to sue, let's say like a Tennessee or a California LLC, if I were to sue your short-term rental and win, I could get a forced sale order to make you sell that asset so that I could gain access to all the equity and anything you had in that LLC. But if you have which we'll talk about here in a little bit, a holding company strategy, or you bought a property in a state that had charging order protection, you couldn't be forced to sell. You could literally wait out that lawyer. And I've actually had that happen to me before when I was bringing these lawsuits, if someone knew how to set that up. So that's mistake number two. I'll give you one more because I know I could just keep going on here.
I know.
The third one is putting multiple properties in one LLC. And I see people do this because they'll say, well, if I have an LLC, I'll just put, 3 or 4 properties in there. The problem is it's like putting all your eggs in one basket, right? So if one property gets sued and you've got 3 properties in the same LLC, now everything's frozen. You can't move any of those assets out. You can't sell anything because during that period of time, all assets under what's called a fraudulent transfer analysis in courts, they're all frozen now. And so I've had clients where this has happened that before they hired me, they reached out and said, oh my gosh, Jeff, I just got served with papers. I'm going to move some of these properties out of this LLC. And I'll say, no, you can't do that now. It's too late. So ideally, unless you're talking about a series LLC, ideally you want to keep each property in its own separate LLC if you can. If they're, unless you're talking about really low value properties, it makes sense to keep them separate because it makes the lawyer will not have standing to bring those other assets and those other LLCs into court. So those are three big mistakes that I see that are kind of common misconceptions.
Yeah, and then again, you talked about something that a lot of people worry about, especially as physicians, right? That which is like there's inside protection. What if something happens within my property, and then what if something happens outside of my properties? And then how do I make sure these properties aren't attached to any judgments that happen because of me functioning as a physician, or if I'm involved in a motor vehicle accident or something like that, right? And that's
Yes.
where that charging order protection comes into place. But before we deep dive, because I know you can go on and on and about this because there's so much to talk about. Let's start off maybe with just the layered asset protection, right? Where do people start? And I always feel like, you want to keep it simple, but you still want to keep it scalable. And, I know you talk about something very similar because the more complex your structures are, there's more protection, but there's also a cost associated with it. So
Yes.
let's talk about when someone is just starting out, right? Because I would say 50% of the people within our coaching program, and physicians in the community are just starting out, right? So when someone's just starting out, what do they start off with? And can we talk about that layered asset protection? I know you also talk about low risk and high risk assets. So maybe let's start there and then just build from there.
Yeah, so great point. So a lot of this, I'll be kind of speaking a lot about short-term rentals, but it applies generally to real estate. But one of the things I look at is when we talk about, I like to create visuals for potential clients where I show exempt assets and non-exempt assets. So exempt assets can include things like your homestead. Every state has a certain amount of homestead protection. Now, some states are pretty weak, like, as low as $20,000 in protection, and other states are as much as like Texas and Florida are unlimited, right? So, but you want to assess that homestead protection is important. You have a certain amount. If you have 401ks, like let's say we're talking about employer sponsored 401ks, IRAs, maybe life insurance policies. Those are all for employer sponsored 401ks are protected under the Employee Retirement Income Securities Act, the federal law that basically says whether you file bankruptcy or you get sued, no one can ever take that. So that generally speaking, I tell people you're protected there. And even if you have IRAs, let's say you've got your own IRAs that you've set up, those are protected up towards, I think they're like the ceiling's now like 1.7 or 1.8 million. So the first nearly 2 million in value is protected from a lawsuit, and you could kind of diversify those into different accounts. And then finally, your life insurance policies are protected. So these are important, but I'm going to warn you, I get a lot of people who reach out to me and say, Jeff, I'm going to set up a self-directed IRA. Well, if you set up a self-directed IRA and you take that and now invest in short-term rentals, you are actually now converting a exempt asset to a high risk asset because those properties can be sued and it acts as a backdoor into your self-directed IRA. So I warn people to be very careful. You can still do it, but you have to use asset protection strategies in order to protect that. Then that leads us to non-exempt assets, which of course, the most vulnerable are going to be the situations with rental properties, right? Now, sometimes I'll have physicians come to me and say, Jeff, I've got a second home, no one else stays in it, or I've got a property that's not a rental property. Well, that's a much lower risk asset. You count that as kind of like an asset in your personal name that you don't want somebody to get access to, but it's not someone staying in the property. So when we start talking about rental properties, those are some of the highest risk assets that you can own because of your duty as the owner. Under just basic tort law, you have a duty of care to anyone who comes and stays, particularly if it's a commercial exchange. They're paying you. You have a duty to provide a safe premises to them, which is the basics of premises liability law. But as a result of that, not everybody, doesn't mean it has to be your fault to end up getting sued. So when we start looking at that, that's when we say, okay, what are the layers to protect down here? How do we protect ourselves for the high risk assets? And I start with two things that really don't cost much of anything that everybody can do, which is number one, have a lease agreement where you actually have the guest sign. And this is one thing that almost no one does. Very few people, they count on Airbnb and VRBO's house rules and Airbnb to act as some great mediator that's going to actually act in their best interest. I hate to tell you, that doesn't always end up that way. Airbnb has a business model that they're interested in making money. And many times that doesn't necessarily mean their air cover is going to take care of anything that you need. And if you ever want to evict someone, if you have to kick somebody out, one of the things that the sheriffs are looking for, anybody that you're trying to bring in action, they're going to ask, where's your lease? What's the contract here? And they're not going to care about what you point to on Airbnb. So I like to make sure a couple of things are in your lease agreement. Number one, you want to make sure you have liability waivers for high risk amenities that you might have on your property. And depending on your state laws, liability waivers are more effective in certain states than others, but that's part of what we do, is to help make sure that's vetted. But they work. In a lot of states, those liability waivers work, because now that person is assuming the risk. They know if they get in a hot tub, they can't get drunk and just do whatever they want, because you have identified that as a high risk amenity that they have initialed off on. Same thing with a pool and the rules and everything that's posted. And then the other thing that people don't think about is credit card authorization forms and chargeback protection. This happens a lot to short-term rental owners. And I had a client who, somebody through VRBO attempted to do a $35,000 chargeback on their stay at an OBX property in North Carolina. And because of the credit card authorization forms that we had, that VRBO ruled against the tenant and ruled for the client, and they kept their money. So, and I'm telling you to say this, merchant accounts give the benefit of the doubt to the customer, not to the merchant. And so unless you have that dialed in, many times you will lose chargeback attempts, because that happens a lot on booking.com. And so all of those type of different sites, platforms have different rules on that. So that's number one, lease agreement. Number two is make sure you have the right insurance. And I know we haven't even gotten into the LLCs yet. When I talk about layers, the ultimate easy button for a lawyer is if you provide the right insurance and you're properly insured. If you set up everything else correctly with your structure, you're incentivizing the lawyer to go to the insurance and not try to sue you, because they understand they have much more to lose in terms of potentially not being able to get access to you through the right structure. So here's a staggering statistic. I think it's like 72% of short-term rental owners have either no commercial coverage because they just got a second home policy, or they're woefully underinsured. So if you're okay with it, I'm going to give just a couple of things.
No, and I love this, Jeff, because mostly attorneys will talk about all the LLC structures and the umbrella, the holding LLC, but this is so relevant to short-term rental owners. And then this comes from your background of being a short-term rental owner, so go for it.
100%. This is stuff that people can go right to right after this and look and see if they're covered. And one of the first things is to usually between page 60 to 90 on your policy of your actual policy, you're going to see a section that speaks about exclusions. And when you go to that exclusion section, this drives me crazy, because a lot of insurance agents will tell you, oh, no, you're good. I know it says that it's a second home policy. We'll add a little rider in there. You're okay. But if you go to that exclusion section and you see anything in there that says business or commercial use exclusions, you're done. You have no coverage. And if something bad happens because a guest is there, then you're going to end up being in a situation where if the insurance company can deny your claim, they're going to, and the burden falls on you to read your policy. Okay. So that's the biggest thing, is many people think they have coverage and they don't. And I hate to tell you this, true commercial coverage, you'll know because it costs more. Okay.
Yeah.
You have to pay more for that good commercial coverage, but that's number one. And then I'm going to give you some quick layouts here. Number one is go look at the premises liability protection section of your policy. Generally speaking, most people are very underinsured. You want to have a minimum of $1 million up to $2 million in coverage, minimum $1 million to $2 million in coverage on the liability section. Check the medical section. Sometimes the medical payout can be very limited. I've seen policies as low as $3,000. That doesn't even cover a trip to the ER, right? So you want to make sure that is covered and dialed in. Then you want to make sure you have what's called loss of income. Loss of income is if your guest burns down the kitchen and now you can't put it on the platform for 2 months because you have to renovate. If you have a true commercial coverage, if when you ask for loss of income coverage, they're willing to give that to you as part of the policy. If they kind of just look at you weird, you don't have commercial coverage. You want to make sure that's dialed in and that it helps you cover your carry costs. And then finally, I think about all these poor people, even in California, that had short-term rentals with the wildfires and all the things that happened out there. That happened in Tennessee not that long ago, a couple of years ago as well. You want to make sure, what is your property currently insured for? And is there a gap between the rebuild cost and what the insured amount is? So that all risk policy, this happens a lot to people who have owned a property for like 4 or 5 years. Well, values have gone up, but unfortunately construction costs have gone up too. So you might be insured for, 1.2 million, but it might cost 1.7 to build it. Well, guess what? You're going to have to cover the difference if something bad happens to the property. So those are 3 big areas. Anytime I talk to someone, you got to get those 2 dialed in before we even speak about an LLC.
Yeah, absolutely. And I think maybe we should talk about the LLC first. And I guess the question I had is, what about commercial umbrella insurance policies? Is that something you recommend for short-term rental owners, or, if
Yeah,
they
great.
have it in an LLC, is that something they don't need to worry about?
So great question. So a lot of times, and I just spoke to a physician just this week where they said, Jeff, look, I'm trying to get a commercial umbrella for my short-term rental. The problem is they didn't have it in an LLC. And so what'll happen is this. If you can go to companies like Proper and all these other companies where you could possibly get commercial coverage and it's in your personal name. But if you want to get a commercial umbrella and you have this in your name, you're not going to get a commercial umbrella policy. Underwriting's not going to do it because it's not a business. They see it in your personal name. And so many times you're not going to get that commercial coverage. And so what I remind people to do is this: shop out the complete depth of your primary policy first. Before you start trying to go add an extra portion through an umbrella, you can many times go from $1 million to $2 million in coverage for a very small increase in your premium. I would rather fully exhaust that, because remember what a commercial policy does, or a commercial umbrella. If you do not fully exhaust the underlying policy, or if it's denied at the lower level, you never even get to the umbrella.
Right.
So I tell people, if something weird happens down here, you don't even get to the umbrella. So you've got to make sure. I like to try to maximize and optimize my primary policy, and then you can start looking at a commercial umbrella.
Makes sense. Makes sense. Okay. Ready to move on to the next layer, which I think is very, very important, especially with a higher risk asset like short-term rentals, right?
Yeah. So now that we've covered lease agreements, commercial insurance, and then we start talking about obviously an LLC. So if, I kind of got into this a little bit earlier, but if you are currently purchasing a short-term rental, you need to look at your state laws. The first thing you want to do is, where am I buying? It's the number one question, because there's 2 big questions I want to know. Number one, if I'm buying in a state with a real estate transfer tax, I need to know that on the front end so I can take strategies to avoid that. And if I'm going to use a commercial loan, I can close in an LLC and I can avoid every bit of that. No worries about the tax. If I'm using a conventional loan, which I don't blame people because you can get a much lower rate, it's easier to do, then you sometimes want to use a different strategy rather than, I see these on these Facebook posts all the time where people will say, I'm going to just do a quick claim deed from my personal name into an LLC after I close. You'll get hammered with a tax. California, this happens as well. You can use what's called a land trust. And if you use a land trust strategy, which I'm happy to explain very quickly what that is, that land trust will help you avoid 2 big issues. Number one, it will help you avoid the real estate transfer tax in every state except for Idaho and Washington state. So you can use this strategy to avoid a real estate transfer tax, except for in those 2 states. But when you do this, here's the great thing. It avoids that. And then it avoids also the due on sale clause issues for any concern you might have in your mortgage. So if you have a conventional loan, I got a lot of people who come to me and say, Jeff, I've got a 3.1% interest rate. I'm worried that my lender might come to me and say, you didn't get my permission to transfer this into an LLC. I don't want to lose my rate. Well, under the Garn State Germain Act, a federal law from 40 plus years ago, it allows you to use a land trust to avoid those 2 consequences. So here's the way it works. I'll give you a quick layout. I'm going to give a 30-second here because I know this is just part of what we're talking about. So when you have a land trust is a simple grantor trust, not unlike a living trust. It's very similar to a living trust, except it's used exclusively for property. Now there's 3 parties to a trust. The first part is a grantor. That's you. You grant the property into the trust. The second party is a trustee. Ultimately, you would be that trustee. But we talk about some ways to establish privacy on that. But the most important part is the beneficiary. Here's the amazing thing. On a land trust, you can assign your beneficial interest as the beneficiary to an LLC, which now a lawyer will have to sue if they want to bring a lawsuit. But your title and your debt remains in the trust, which means no transfer tax because there was no title transfer. Okay. So you avoid the tax, you avoid issues with your lender. And if you ever want to refinance in the future, people that are buying at 7-8% loans right now, you can actually refinance without having to pay the tax again. Because you got to remember, you cannot ever refi a conventional loan in an LLC. That lender is going to force you to pull it out. And guess what will happen? You'll get taxed again in California, over 1%. You'll get taxed again in most of these other states. So I bring that up to say the next layer is I need to know what state you're in. And if you happen to be in a state like Texas or Wyoming or, Delaware, a state where there are no real estate transfer taxes and it already has good, strong laws in them, then you don't have to worry about that. You can do a general warranty deed transfer, but I know I'm giving you a lot of law here, but it's really important to know this is not just a template thing. You've got to really stop and look and say, what state am I in? What kind of financing am I using? That will help you make sure you get to the first layer on this, which is just getting it into an LLC, right?
Correct. So I have tons of questions here, Jeff, so I'm going to stop you for a little bit.
If you're interested in learning how to invest in long-term and short-term rentals the right way, so you can accelerate to financial independence with the support of mentorship, community, and vetted investor agents in strong markets across the country, then get on the waitlist for the next cohort of Creating Generational Freedom at www.generationalwealthmd.com. You don't have to learn from decades of costly mistakes by yourself. The program is only open for enrollment in the spring and fall each year. In the last 6 months alone, our members have acquired over $60 million of real estate, and more importantly, they're living life and practicing medicine on their terms. You don't have to do it alone.
When you said you're assigning your interest into an LLC, now does that LLC have to be state specific, or can that be the Wyoming Holding LLC? Because I believe, again, a lot of our students, especially some of them on here also, especially those in Florida, do use a land trust. And there's, again, there's always the question of, do I do the land trust? Are there any issues on the back end? Do I just do an LLC and, eat up the cost of the transfer? And so, so the LLC that needs to, that the interest flows into, does that have to be state specific?
So that's really good question. So the first thing is so we're talking about the land trust. Let's talk about the LLC. I like to make sure that we use an LLC in the state where the property is located on that level. And here's the reason why. Because think about this for a minute. For the most part, if I have a property in Florida, if I get sued, what's going to happen? I'll get hauled into a Florida court in front of a Florida judge, and Florida law will be applied. So if I were to just go use some other LLC at this level, what'll happen is that's considered a foreign LLC at that level. And then I'll end up paying registered agent fees for both states. I have to report for all my filing requirements in both states. And I don't get any extra benefit of the law there. There is one exception. There's always exceptions under the law, right? And one of those exceptions is in Florida. Florida has one of the very best, if not the best, land trust law in the country. Most other states, you do not have any real asset protection in a land trust, but Florida, you do. So normally in Florida, so here's the deal. If you were to come to me and say this was in California, I would say that you need to do that you would need to start and move it into a land trust, assign your beneficial interest into a California LLC, and have that single member LLC held by a preferable holding company like Wyoming.
Wyoming, right? Okay.
But that's because California law, I hate to say this, is terrible. It's just really bad for you. It's not good.
I'm from California, so I hear you. You don't have to, you're preaching to the choir.
Yes, but Florida's different. Florida allows you to skip one step. You can actually do a transfer into a Florida land trust. You can go directly to do an assignment of beneficial interest into the Wyoming LLC if you want to.
Okay.
Because here's the reason why, and I haven't even gotten into the specifics about that Florida law, but Florida has no privacy and it has no charging order protection. But because it has very strong land trust laws, I can bypass the Florida LLC requirement and go straight to assigning it into a Wyoming LLC. That has held up in case law and in court. Okay. Now, in almost every other state, though, you need to go land trust to state level LLC, single member, held by the preferential holding company state.
Okay, that makes a lot of sense. And then, like you said, again, it depends on the state you're investing in. A state like Texas, which is where I've I hold a lot of my personal
Yes.
portfolio. I've never had an issue. I've just had an
That's right.
LLC. I transfer in and out, really don't get hit with a lot of additional costs. And so that's a valid point. So it becomes very unique to, where you live and where you're investing and a lot of those questions. And so the due on sale clause, Jeff, I really want to touch upon that a little bit because for the longest time, it wasn't something we were seeing a lot, but I heard you mention somewhere recently where you're seeing that happen more often just because interest rates are higher now. Is that a trend that you've seen shift over the last few years?
So let me be real clear. It's not, I would not say it's a high risk, but even Bigger Pockets did an episode about 9 months ago that said they've seen like I don't know, a threefold or whatever it was increase in due on sale clause investigations. And here's the biggest reason. As my general rule, if you have a loan sub 4%, you are at a higher risk. And the reason why is, think about it, the bank is losing money on your loan. I've got an interest rate on one of my short-term rentals, it's like 2.8, right?
Yeah.
Well, what's the delta between 2.8 and current market rate? If the lender sees that I'm doing this, and there's a couple of them that are the worst, like I'm just going to tell you, there's a few of them, I won't name names, but if you have questions, you can let me know and I can tell you. There are a few of them that are offenders on this where they'll look at it and what they'll do is they'll go, oh, hey, you didn't get our permission to move this over. So you have two choices, either pay the entire note right now, or we're going to accelerate, we're going to move your rate up to market rate. And I personally, with clients that came to me that were not my clients, but people who came to me in a panic last year, I had 5 people that happened to. Okay. Now that's not very many. That's not very many, but as a lawyer, my job is to let people know if you have a super low rate, there is some risk, not very high risk, but it's a risk enough that you should be aware of it in case that were to happen.
Yeah, that makes sense. And it's always important to go in having all that information. And so we talked about the land trust. And so even in states that aren't Florida, where the laws for land trust aren't as strong, you feel like there are situations where, say, California, it makes sense to potentially have a land trust and not have issues on the back end when you're selling or when you're transferring in and out, in your experience?
That's a great question. Here's what I ask clients all the time. I'll say, let me say this. Do you think there's a chance? Well, number one, let's calculate just the pure ROI on what are you going to pay the government if you do a title transfer on your own straight into the LLC, if you got to pay the transfer tax post-closing. And then number two, is there a chance you're going to want to refi? What if rates do go down? Which I know they keep saying there's a chance, and then who knows if they will. But if they actually do go down, people are going to want to get out of some of these 8%, 7% loans. They're going to want to try to go down and it'll cut their carry costs. If you don't have a land trust option set up here, you'll have to pay, like in California, the lender's going to force you to pull the title out of the LLC to refi. Tax. When you do that, you'll be taxed. And then when you finish the refi, you're going to want to get asset protection. You'll get double taxed. You'll get taxed again when you put it back in. So I see it as a pure mathematical equation. I tell people, look, if the cost of the land trust is going to be worthwhile to you and it doesn't create any extra taxable filing requirements or anything extra at all, if that's going to give you the flexibility of knowing you can refi without paying a big tax, then to me, it's worth that as a solution.
Makes sense. Makes sense. So we've touched upon the lease agreement. We talked about insurance products, and we're kind of moving into land trust / LLC zone. So as we talk about the LLCs, Jeff, I think a question that comes up quite often is the timing of creation of the LLC. So someone knows they're going to invest in Florida. They're looking at properties with their agent. When do you recommend they start thinking about, getting those documents in and creating the LLC? And I know you kind of talked about piercing the corporate veil previously, but what are the steps they need to take to make sure that they're, in compliance essentially?
Yeah. So, first of all, I always recommend, unless you know 100% sure where you're going to buy your property, what state, just be careful. Like sometimes we like to plan. We get excited about buying a property and we're like, I'm going to buy a property. And then you just go open up an LLC and then you have a Florida LLC, but you buy in North Carolina, right? It's like, okay, hold on. There's enough time to set up a proper LLC. Generally, I tell people once you find your market and you're about to start putting in offers and you know this is what you've settled on, you're going to have the time to structure your LLC during that period of time so that you're able to get that done. But this goes back to your point. Here's the reality. Anybody can set up an LLC. You can just get on a Secretary of State website, push a button and get a certificate of formation. The problem is, That's not what protects you in court. What really matters is a well-drafted operating agreement. The operating agreement needs to be well crafted, because the downside is a lot of people will go onto online services to set up an LLC, and they'll come to me and I'll say, well, let me see your operating agreement. They'll go, what is that? And they don't even know what it is. And if you actually get sued, the judge will look over and say, I need to see the rules for the relationship. Where's the operating agreement? The certificate of formation means nothing. And so it's important to make sure that when you do structure these, you have a well-worded operating agreement, especially if you're doing a partnership. I have a lot of people who will say, hey, my friend and I, or my brother and I, we're going to go into this big short-term rental together. You really want to craft the terms of that partnership agreement into the operating agreement for your LLC. So not only does it protect the relationship that you have, but it also actually acts as the rules for your LLC. So that's number one. Number two is you have to actually have a bank account. I'm shocked at how many people set up an LLC and then they just operate out of some other account. You get an EIN number, work everything through the bank account, right? And then when we talk about piercing the veil, the number one reason why the veil can be pierced is because of commingling of funds. So what'll happen is once you do set that up, all of the money you receive from Airbnb and VRBO or whatever you receive it from goes from that source into that bank account for that LLC. And then if you have a holding company, you can take distributions from the holding company, but otherwise treat each of your properties in their own LLCs on their own little island. Okay. Because otherwise what you don't want to do is just use your holding company like a slush fund and just dump a bunch of money in there or pull money out whenever you want to. This is why I'm always telling people asset protection is great. We create the boundaries and the fences legally, but you need to also work with a bookkeeper and a good real estate CPA, because the bookkeeping shows the money movement, and that's how it protects you from the veil being pierced.
Yeah, such valid points, Jeff. And I feel like we're going on and on. We could go on forever, but maybe it's time to move on to the next level of protection, right?
Fair enough. So let's say now we're looking at, I'm going to tell you, use the example, Param, a second ago about Texas. You know, sometimes people come to me and they literally bought a property in Texas, or they bought a property in, Jackson Hole, Wyoming, or something like that. And I'll tell them, if you only have one property and you bought that property in a state that has really strong laws, you don't need any other holding company or anything like that. You're good. You're in a great state. But unfortunately, that's not usually the way it is. Most people that are multi-state investors, particularly with short-term rentals, buy in states that are very popular to visit that don't have very good laws. So I've already covered with you the privacy and the charging order protection. So what if you buy a property in, Joshua Tree, and it's beautiful, and the problem is you got terrible laws there? How do I protect my assets? Well, the only way to protect the property in a poorly protected state is to use a holding company strategy. And that holding company strategy, there's several states that have some of the strongest protections. And I'm going to start with kind of the smaller investor first, is you can use an LLC set up in a preferential state as your holding company, and you can actually technically use that state's preferential laws for that poorly protected property, right? And so a good example is California. I would have that property held in a California LLC, but it would be a single member. That single member is not you. It's, let's say, a Wyoming or a Delaware LLC. And now you're listed on the Wyoming or Delaware LLC. And here's how it changes. I'm going to give you the anatomy of a lawsuit. If I were to normally go sue you in California, the California Secretary of State would tell me who you are. I could do an asset search on you, and you would have no charging order protection that we talked about earlier. But the moment we make it a single member held by the Wyoming LLC, when I go to the Secretary of State in California, they go, we only see one member, and it's a Wyoming LLC. So we have to go to Wyoming. When I get to Wyoming, privacy. They won't tell me who I'm suing. I won't know that initially. They also charging order protection, which means this: if I sue you and I win, you can wait me out. Now you can't pay yourself an owner's distribution, but you can keep all the money in there, pay all of your expenses. I've actually literally seen people wait out lawyers for years. Now I'm going to tell you, as a personal injury lawyer, that's terrible, because the lawyer has to take the case on a contingency fee. I have to pay all those expenses out of my pocket, and I don't get paid. Like, I don't want to sue somebody where I might not get paid. So what does that make me do? It incentivizes me to go down to that insurance we talked about earlier. Mm-hmm. When I get down to that insurance, I want to take a bite there, because the one thing a lawyer doesn't want to do is be left in the red in a lawsuit, right? And so it incentivizes that lawyer to get an insurance settlement. That piece right there, you can't get in most states. There's only about 5 or 6 states in the whole country that provide you decent enough state level protection that you don't need a holding company.
Yeah. And then Wyoming seems to be the preferred one. I guess that's from a cost perspective and just legislation perspective.
2 reasons. Number one, it is easy to maintain. It is cheaper filing fee than most of the other states. But the other reason is it is the first state going back almost 50 years that created these protections, and they've been challenged over and over and over again. And as a lawyer, I like old laws that have been tested that I know are going to hold up. And we know that Wyoming has held up.
Yeah, yeah. Awesome. We started off from lease agreements to the insurance policy, moving on to LLCs, in the state, and then the holding LLC. I feel like maybe, Jeff, I'm going to leave it to you. I know we hear about DSTs, and I know you talk about Arizona limited partnership holding companies. So what is the next level if there is one, and
Yeah.
who should even consider getting to that point?
So great question. The only negative to using a LLC holding company strategy like a Wyoming LLC is that once you scale out your rental portfolio, let's say you get to like 7, 8, 10 properties, there's a negative that if one of those properties underneath that Wyoming LLC holding company gets sued, everything in the holding company freezes. So there's something called a fraudulent transfer analysis that takes place. So let's say under that arrangement, if one of my properties got sued and I've got 9 other properties, I couldn't during that period of time sell any of those assets during the litigation because that would be seen as a possible fraudulent transfer. Like I'm trying to skip out on the whole litigation. And so somebody can't get to any of this stuff. And there are clawback provisions where the court can actually pull those assets back into consideration. The other problem is if you've got like, let's say you've got one of your properties is the goose that laid the golden egg and it makes you more money than all the other ones. And you're used to using that to help prop up some of your other struggling ones. You cannot use the funds from that property that was sued to help support any of the other properties because that is seen as a fraudulent transfer. So many clients, I've got a client with over 100 rental properties and they say, Jeff, I can't be held hostage by one lawsuit. What do I do with these other assets? That's where the Arizona limited partnership can come into play. The limited partnership, and I'm going to give you a very quick high level, and then we obviously there's a lot of complication to it, but the limited partnership has 2 partners. There's a limited partner and a general partner. The general partner under limited partnership law is the liable partner. Well, the limited partner is the non-liable partner. Real estate syndications work off of this all the time, right? Mm-hmm. Grant Cardone's doing a fund. Well, the GP is Grant Cardone. He's the one liable. If I put money into it, I don't know what he's doing. I shouldn't be held liable for that. Well, you can use this in Arizona. There's a statute that allows you to do this. And it's wonderful for what I call family real estate office arrangements. And what you can do is have a trust as the limited partner that owns 99.5% of the portfolio. Then you can have a Wyoming LLC that's the general partner that owns 0.5% of the portfolio. And here's what the law says. It says, in the event of a crisis event, which a lawsuit is a crisis event, the limited partner trust can take 99.5% of all those assets and leave post-lawsuit in the middle of the lawsuit as long as 2 things are present. Number one, you had to set this up before you got sued. And number 2, you have to make sure the limited partnership provisions in the agreement allowed you to do this. That's the non-fraudulent reason. Just like I would want to run away from Grant Cardone if something bad happened that he did, it allows this to be a non-fraudulent purpose. So the benefit to this is it provides you post-lawsuit flexibility so you can manage these other assets, do 1031 exchanges, be able to make the decisions that you want to make as an investor, but you also diversify your risk. Now you have a smaller portion of what that remaining amount was in the general partner Wyoming LLC and only the original property that was sued. This works really well. That's why I have some really high net worth clients, 100 million, whatever. They also use things like foreign asset protection trusts in that space, or a bridge trust, or what they call them trigger trusts. Those can be used in that spot. But I like what you said earlier, Param. Not everybody and almost nobody needs those. You only need what you need as you grow. You don't need to put some big, huge thing in place that requires all these administrative expenses and all this management, when in reality, just get started with what gives you the protection you need. And then as you grow big enough, your cash flow will increase and you can invest more in that.
That makes absolute sense, Jeff. I'm almost tempted to not ask this in the interest of time, but I'm gonna ask you anyways. Series LLCs, is there a situation where you recommend them? In what states? And does it matter where you live?
Yeah.
Just if you could just give us a quick overview.
Yeah. So series LLCs. So I know, there's a lot of contention about this. The ABA, the American Bar Association, doesn't recommend them because they're worried to some extent about if you put, let's say, for instance, you've got Texas recognizes series LLC, so does Oklahoma and Missouri. Let's say you've got properties in all three. Well, if you put all of them into one series LLC set up in Texas, the problem is you're putting a lot of faith in different judges and different jurisdictions with different laws that they won't bust that LLC if you get sued. As a general rule, what I like to do is if you're going to use a series like yourself, let's say you've got 4 or 5 properties in Texas, I feel very comfortable with putting all 4 or 5 of those into cells of a Texas LLC. But I don't like mixing and matching properties from other states into that series, even if it's allowed, right? Because you're creating a risk that if that property in that other state is sued, the fate of your property in a different state is in the hand of a judge who can apply different law, right?
Yeah.
And so I like, if you're going to do it, group properties state-based under each series and not grouping them all together.
Yeah, it makes a lot of sense. Unfortunately, I'm in California, which does not recognize Series LLC, so that's not even an option for me. But
Right.
thank you so much, Jeff. You are a wealth of knowledge. It's been so much fun going over all of this with you. For those of you listening, guys, for members of our community, Jeff's team, they're doing us a solid. You do get a free consultation and a customized roadmap if you go through us. If you go to generationalwealthmd.com/attorney and fill out the form and check the box where it says, please introduce us to STR Law Guys, then you do get to you get to take advantage of the free consult and customized roadmap. And like Jeff said, all of this has to be uniquely personal depending on where you live and the states that you're investing in. And so I highly recommend doing that. Thank you so much, Jeff. This was so beneficial, Jeff. And it's also a time where, a lot of our students, end of the year, they love getting into STRs. And this is the time where they're considering all of their asset protection options. So this was super helpful. Thank you so much.
Well, thank you for bringing me on. I enjoyed it.
Absolutely. Thank you, guys.